Welcome back to the deep dive. This is where we, try to cut through the complexity of specialized knowledge, specifically U.S. patent practice. We want to give you that shortcut to expertise.
That's the goal.
Today, we are definitely plunging deep. We're heading straight into the Manual of Patent Examining Procedure, the MPP, Chapter 1400, which is all about correcting patents after they've issued.
And our specific focus today is even narrower. MPP Section 1403. It's titled Diligence in Filing Reissue Applications.
Right. So timeliness. How fast do you need to be? We'll unpack the rules, the guiding principles, and how the courts have interpreted this.
Exactly. It's fundamental stuff if you're working with patents that need fixing.
Okay. Now, before we get into the nitty-gritty, we really want to give a special thank you to Mike Shepard. He's the creative director who put this whole audio series together.
Yes, thanks, Mike.
And, of course, the disclaimer we have to include. This summary was generated using AI tools, ChatGPT, Notebook LM, so it might have errors, maybe omissions. It's really just for general educational, informational purposes.
Absolutely. It is definitely not legal advice.
Yeah.
Don't treat it as formal instruction.
For the authoritative word, you absolutely must go to the official MPP or, talk to a qualified instructor or a registered patent practitioner.
Couldn't agree more.
All right, let's set the scene. A patent owner realizes, oops, my patent has a defect. Maybe a claim is too narrow, maybe inventorship is wrong, maybe it's just unclear. They need a reissue application. What does diligence actually mean? How timely do they need to be?
Well, the MPP gives us a really strong, practical starting point. It centers around a 2-year time frame. Section 1403 lays out this powerful presumption.
A presumption, okay.
Yeah. If you file that reissue application within 2 years from the date the original patent was granted, the USPTO generally presumes you filed it diligently, with timeliness.
Ah, okay, so that's like a safe harbor then. If I spot an error, say, 20 months after my patent issues, and file the reissue, I'm probably okay on the timing front.
You're more than probably okay. Examiners are actually told, don't reject your reissue just for lack of diligence if it hits that 2-year window.
Even if it's filed right on the 2-year anniversary.
Even on the 2-year anniversary date itself. That presumption is quite robust.
But wait, that 2-year mark? It's not just a presumption for everything, is it? I thought there was something stricter for certain types of correction.
You're absolutely right. And this is like the first really critical thing to nail down. We shift from a presumption to a hard stop, a statutory bar, under 35 U.S.C. Section 251-day.
Okay, Section 251, what does that do?
It says if your reason for filing the reissue is to enlarge the scope of the claims, what we call a broadening reissue, you must file that application within those 2 years. No ifs, ands, or buts.
Must file. So after 2 years, that door is completely shut for broadening.
Completely shut, slammed, logged, barred. Congress put that strict limit in place very deliberately.
Why? What's the thinking there?
It's about public reliance. Once a patent grants, the public, competitors, researchers, they look at those claims and make decisions based on that defined scope.
Right. They rely on knowing what's protected and what's not.
Exactly. Allowing a patent owner to come back years later and say, actually, I meant to claim more. Well, that would create a lot of uncertainty. It could really farm people who designed around the original narrower claims.
So the message is, fix your errors, yes, but if you want more protection than you originally got, you've got a strict 2-year window. After that, tough luck.
Precisely. If you realize at month 18 you need broader claims, file then. If you wait until year 3, forget about broadening. It's just legally impossible.
Okay, that seems pretty clear-cut for broadening.
Yeah.
What about the other way around? What if you realize your claim is actually too broad? Maybe you found some prior art or there's a double patenting issue. You want to file a reissue to narrow the claims.
Now that's where things get, shall we say, more interesting, more nuanced.
Because you're giving scope back to the public, right? So why would timeliness or diligence still be a major issue there? There's no 2-year statutory bar against narrowing, is there?
No, there isn't. But, and this is a big but, the courts have stepped in. They've made it clear that the overall requirement for diligence can still apply, even to narrowing reissues.
Okay, how so?
This is where case law becomes really important. The key case to understand here is, in Rosuvastatin Calcium Patent Litigation, it went to the Federal Circuit.
Rosuvastatin, got it. What was the deal in that case? What were they trying to fix, and why did diligence become such a sticking point?
Well, the patent owner needed to narrow their claims. Part of the reason was to deal with potential problems like double patenting or maybe validity issues over prior art. The problem wasn't that they were narrowing, but when.
Okay, the timing again. How long did they wait?
It was a significant delay. We're talking years after the original patent granted. And crucially, there was evidence suggesting the patent owner kind of knew about the underlying problem for a good chunk of that time before they actually filed the narrowing reissue.
Ah, so they knew there was an issue, but sat on it for years before trying to fix it by narrowing.
That was the argument, essentially, and it caused a split at the court. The majority ultimately decided, based on the specific facts, that the applicant had been diligent enough.
But there was disagreement.
Oh, yes. The dissent argued very strongly against finding diligence. They focused on that long delay in addressing a known defect. Their point was, basically, how can you call that diligent?
Wow. So the fact that there was such a debate, even for a narrowing reissue, that's the real takeaway here, isn't it?
I think so. It tells you that you can't just breathe easy because you're narrowing claims and are outside that 2-year window for broadening. The courts might still scrutinize your behavior.
They're looking beyond the statute to the spirit of the law.
Kind of. The reissue statute is meant for correcting genuine errors without deceptive intent. If you knowingly sit on an error for years and years, even if you eventually try to fix it by narrowing, a court might ask, was that delay really diligent, or was it strategic? Were you trying to maybe extend your effective market power or dodge challenges by waiting?
Right. So prolonged, unexplained delay in fixing a known issue could potentially sink your narrowing reissue, even if it's filed 5, 6, 7 years after grant.
It's a risk. The Rosuvastatin case highlights that diligence isn't just about meeting the 2-year broadening deadline. It's a broader standard of conduct that can be examined, especially when significant delays are involved after a defect becomes known.
Okay, that adds a whole layer of complexity. It leads me to a practical question, though. We've established timing is critical, especially hitting that 2-year mark for broadening. What happens if you're rushing to file and, well, you mess up the paperwork?
Yeah, like forgetting something important.
Exactly. Maybe you forget the oath or declaration, or you don't get the fee payment submitted quite right. Do you lose that critical filing date because of a formality?
That's a great question, and actually, the MPP addresses this directly in Section 1403. The system has a built-in procedural safety net.
Oh, how does that work?
Basically, you can still be granted a filing date for your reissue application, even if some of those formal requirements are missing when you initially submit it.
Really? Like which ones?
The most common ones are things like the oath or declaration, or maybe the filing fees haven't been paid yet.
So let's say I file my broadening reissue on day 729, just under the wire, but I forgot to include the signed declaration. I still get the filing date of day 729.
Yes, that's the crucial part. You get that filing date locked in. You don't lose it because of that kind of fixable omission.
Wow, that's huge, especially for broadening.
It's incredibly important. The system recognizes that losing the filing date over a formality would be too harsh, particularly when statutory deadlines like the 2-year broadening rule are at stake.
So what happens then? You just get away with it?
Not quite get away with it. You'll be given a notice, usually, and a time period to correct the deficiency. Submit the oath, pay the fee, whatever it was.
And probably pay extra.
Oh yeah, there are usually surcharges or petition fees involved. But the key is the filing date itself. The date that determines if you met that 2-year deadline is preserved. It prevents a technical slip-up from having catastrophic consequences on your ability to reissue.
Okay, that makes a lot of practical sense.
It does. So let's try and maybe summarize the key takeaways from Section 1403 for you.
Good idea. Let's consolidate.
Okay, first, and maybe most importantly, for broadening reissues, that 2-year deadline from the original patent grant, it's absolute. A hard statutory rule from 35 U.S.C. 251 Tech. Miss it, and you cannot broaden, period.
Got it. Rule 1. 2 years for broadening, no exceptions.
Second, for any reissue application, broadening or narrowing, filing within those first 2 years creates a very strong presumption that you acted diligently. Examiners generally have to accept that timing is okay.
Okay. Presumption of diligence within 2 years.
Third, the courts, especially highlighted by cases like Rosuvastatin, show us that even for narrowing reissues filed after 2 years, your overall diligence can still be questioned.
Right. Particularly if there's a long delay after you knew about the problem you're trying to fix.
Exactly. Known defect plus long delay, potential diligence problem, even for narrowing.
And fourth.
Fourth, there's procedural flexibility. You can secure your filing date even if you initially forget formalities like oaths, declarations, or fees, though you'll have to fix them and likely pay extra later.
So putting it all together, The MPEP sets up these timeframes and presumptions, kind of like the basic rules of the road for
All
examiners.
right. They provide clarity and predictability for the most part.
But the courts remind us that diligence isn't just checking a box on a calendar. It's also about your behavior, how promptly you act once you know there's an error, regardless of whether you're trying to get more scope or give some up.
That's a perfect way to put it. The administrative rules provide a baseline, but judicial review can look deeper into the patentee's conduct over time.
Okay, lots to think about there.
Definitely. And maybe here's a final thought for you to chew on, kind of spinning off that Rosuvastatin tension.
Go for it.
If the whole point of reissue is correcting genuine mistakes, honestly, without deception, how long should we really allow a patent owner to take to fix a mistake they know about? At what point does just letting it sit, even if you eventually narrow it, become, well, maybe not deceptive, but certainly not diligent? When does the delay itself undermine the purpose?
How long is too long, even if the intent wasn't bad from the start? That's a tricky one. Something definitely worth mulling over as you dive deeper into Chapter 1400.
Indeed.
All right, that wraps up our deep dive into MPP Section 1403 on diligence in filing reissue applications. Thanks for joining us. Until the next deep dive, stay informed.